Buying a home, it's likely the most money you will ever spend at one time. Make sure you have a real estate team you can trust on your side, helping you every step of the way. Welcome back to the Dan Gemus Real Estate Show with one of the most trusted realtors in Windsor, Essex, Dan Gemus.
Okay, welcome back to the show with you till 1 o'clock today and every Saturday and Sunday from noon to 1 here on AM800. Tomorrow we'll be broadcasting outside in front of the office and in front of the Richmond Popcorn Company for open air in downtown Amherstburg. So come on out and watch us live or come out and say hi, and we'll be out there. So before we get to Christian Janisse, we have our Richmond Popcorn Company gift card to give away. Matt Alida and Fatty Alendacci in studio with me today. Matt, you've got the screen, you've got the button.
Yeah, I'm going to press the button.
Press the button. What do you got? Who's our winner today?
It is Mike Dunning.
All right, Mike. Congratulations. There you go. $50 for the Richmond Popcorn Company. And again, over 35 flavors. You can see them all online at richmondpopcorn.com. Taste test everything in the shop. They ship across Windsor, Essex County. They will deliver across Windsor, Essex County, and they ship across the country. So check them out, richmondpopcorn.com. Okay, it's time for Christian Janisse, real estate lawyer, for his segment. And Christian, we've got actually your topic today, and we've got a couple of listener questions as well that we'll get to. So let's get to your topic first. How are you this afternoon?
Oh, not bad. How are you?
Fantastic. It's a beautiful Sunday, and we're having lots of fun. Saturday. I keep saying, thank you, Fatty. I keep saying Sunday.
Don't take our weekend away from us,
Oh, my
Dan.
gosh. Woo. Okay, so your topic today is all about final walkthroughs.
Yeah, so one thing that I see a lot is when I sign with clients, I'll go through all of the paperwork, and then we have one form in particular where I say, okay, have you done a final walkthrough? And at that time, I try to explain to clients like what the purpose of the final walkthrough is. And one thing that always seems to get clients confused is that they think the final walkthrough is a quote-unquote final inspection. They seem to be confused about the fact that you've already signed the agreement. So anything that was already at the property, like any kind of damage or any kind of like defects that you could have seen at first, now is not the time, or you don't have the ability to say, oh, well, you know, your door handle is missing or your window handle is missing. You need to replace that. So it's kind of about final walkthroughs, but also making sure that you examine the property in particular and take notes of anything that you want fixed beforehand, because when you go do that final walkthrough, it's not time to, hey, let's see if I can get some type of windfall and say, oh, you know, never mind, that window's actually cracked, you need to fix it. Well, if it was like that when you put the offer in, that's not the purpose of the final walkthrough. It's to make sure that the house is in the same state as when you originally put the offer in to buy it.
Yeah, if you opted not to do a home inspection and you scratch out your condition, you can't all of a sudden now want things fixed in a property just because, like you said, you want a windfall and you want to just try and get them fixed before you move in.
Yeah, and some of the bigger ticket items would be, and a lot of people think, oh, well, I waived the home inspection, but even before they put in the offer, a lot of people don't check the oven, check the washer and dryer to make sure that it works. Then they'll say afterwards, oh, well, hey, you know, I did the final walkthrough and the stove doesn't work. Well, if it didn't work when you were, like when you originally put the offer in and you didn't check it, I'll say, oh, did you check it at the time that you did the offer? No. Well, okay, now they're telling us, like the seller's telling us that it's always been like that and that you didn't check it. It's just, it's hard news to deliver to clients on closing, obviously. So yeah, I just thought it'd be a good message to tell people, you know, check everything beforehand so that when you do the final walkthrough, you make sure that everything lines up with what your expectations were before you put the offer in.
Matt's got a question.
Yeah, here's a thought. So with that in mind, Christian, if someone, let's say you're doing an earlier walkthrough and you do find an issue, would the appropriate thing to do, obviously you'd want to bring it up with them, with the seller, or the, you know, if it's the buyer's agent, with the listing agent. But would it be a good thing to bring to your lawyer as well and just mention, hey, this is something that we found was an issue. We want to make sure it gets resolved ahead of time?
100%. If it's an issue that it wasn't an issue when you put the offer in and it's an issue when you do the final walkthrough, 100% you should bring it to the lawyer and let them deal with it so that it can try and get resolved. Most of the time they do get resolved, and if it doesn't get resolved, at least you have a record between the two lawyers that, hey, although on closing on the deal, the stove didn't work or whatever it is, you can go back and try and make a claim afterwards. It's really difficult to make a claim afterwards if your answer is, well, I checked the stove on the final walkthrough, and then you're in, let's say you do get to a trial. Well, did you check it before you put the offer? No. You have nothing to compare to.
Mm. Man, oh man. Okay, so on that, essentially, I guess. So, what are some of the common issues, I'm going to ask, Christian, that you're seeing with coming across because of final walkthroughs? What are you seeing? So, I know I've seen in the past people switching out appliances. They came with appliances, and now it's different appliances. What else sticks out?
Yeah, appliances are the big ones: washer, dryer, fridge, stove, microwave. A lot of people will reach out to us afterwards and say, hey, it's the winter. I bought the house in the summer. I went to go turn the furnace on for the first time, and it's not working. AC, the AC wasn't on when I was checking the property. Now I just moved in, and I'm turning the AC on, and it doesn't work. It's mainly the appliances. Those are always the big ones, and a lot of people don't check them because they just assume, well, because if you have a stove sitting there, it must work. But that would be not a good assumption.
Okay, great. And last question on this topic. If there is an issue or something else that we commonly see is people just leave a bunch of garbage, a bunch of stuff in the house. I know a recourse you often do is you'll do a holdback, right? How does that work?
Oh yeah, I was going to leave that as a whole other topic. The broom swept manner clause. I've probably got like 3 or 4 issues this week alone where people were like, "Well, the stove is dirty." Well, what does broom swept manner mean, and what happens if it's not? Let's say you have a deal for $350,000. I don't think a judge is going to look lightly on the fact that, hey, you broke a chain of real estate transactions over the fact that the oven was dirty. If that's what you're trying to do, you're probably going to be penalized. Unfortunately, I don't think that those clauses, I think you should include them just to set out your expectations, but they're not really worth anything if people don't follow them. You can't breach the contract or back out of the deal because the oven was dirty and they left dirt throughout the house when they hired movers and things like that. It's just not practical because the daily interest on a mortgage alone could be $50 to $150.
Yeah.
So that's going to cost you more to deal with that.
Okay, so let's get to a couple of listener questions that came in for you. So number one, there is a giant myth out there that if a home is listed for a certain price and an offer comes in at that price, that the seller must accept it. True or false?
That's false. A seller doesn't have to accept any offer because the way it works for contracts is that you have to have offer and acceptance, and the way that it works, that the house is being listed, it's not actually an offer. The buyers come in and they make an offer when they put out the agreement. In order to have like a firm offer, you have to have an agreement or a meeting of the minds between all of the key terms. So the listing itself would not be an offer. It would be considered in law what we would say is an invitation to treat. So let's talk.
There you go. Yep. So there is no ifs, ands, or buts about it. If the offer comes in anywhere near what the listing is advertised at, the seller can do whatever they want with it. They can just tell it to go away.
Yeah. Now, unless you put in your listing, I know you can add documents. So if you put in your listing a blank offer with a specific closing date and a specific price in the chat, like if you basically put an offer in there and somebody came and said, "I'll accept that," that'd be different. But with the listing, you don't have a closing date. There's a lot of key terms that are missing because there's a lot of things that the realtors negotiate, whether things could be including or excluded. So no, it's not. You don't have any obligation to accept it. You can turn away all offers and just say, "I don't want to do this anymore."
Got it. And last question. Our fun topic today was all about ghosts and whether or not you believe in them. And someone asks, they had a situation where they believe a haunted house. Must it be disclosed?
No. The only thing is that it doesn't have to be disclosed, but if a buyer specifically asks for something haunted, that would be a tricky area. But let's say, for example, a grow-op. It was a grow-op in the past because I've seen that a few times. The seller doesn't necessarily have to disclose it if everything is remedied. like if the seller's not aware of any issues from it being a grow op. But if somebody asks, has this house ever been used as a grow op, and the seller says no, or for example, let's say it was a murder or a suicide, like are you aware of any murders at this house, and the seller is and says no, then that you can't openly lie about things like that.
Right.
If asked.
If asked.
No, the seller has no obligation to go and educate themselves on those things. So if they don't know, they can just say, I don't know.
To the best of your knowledge, yeah. Yeah. Okay. Awesome. Great tips there, Christian. As always, if someone wants to reach out to your team at Simplyclose, what's the best way to do that?
They can send us an email at hello@simplyclose.ca or give us a call at 519-997-3775. Thanks. Have a good weekend, everyone.
Thanks, Christian. That's Christian Janisse, a real estate lawyer with Simplyclose. So there you go. A couple of questions answered for the listeners there, and some interesting stuff. So hope that helps, everyone. Thank you for your questions. We're out of time. Matt, Fatty, thanks for coming today. We appreciate it.
Yeah, flew by.
Reminder, if you are looking to make a move, give the Dan Gemus team a call, 519-566-5565. You can also find us on our website at dangemus.com. A big thank you to producer Tony back in the studio, helping and is amazing as always. And thank you to all of our listeners. We're back with you tomorrow from noon to 1 right here on AM800.